Welcome to Ideas in Flux. I'm your host, William. On March 8th, 2023, Minnesota Governor Tim Walz signed Executive Order 2303 titled Protecting and Supporting the Rights of Minnesota's LGBTQIA+ community members to Seek and Receive Gender-Affirming Healthcare Services. Leading up to the election, there were many claims that Walz's legislation allows the state to kidnap your kids and trans them. I thought this seemed way too extreme to be believable, so I felt I had to look into it myself. Research for this episode also led me to Bill HF 146, a so-called trans refuge bill, which also came out of Minnesota under Walz, because it could be the case that these kidnapping powers were granted in HF 146 instead of Walz's executive order. I've got my sources linked in the description for you all if you want to see for yourself or look into any more of this on your own. In this episode, we'll cover who's making these claims and what they're saying. Then we'll read the executive order together as well as the trans healthcare amendments to Bill HF 146. Then we'll compare the claims being made about kidnapping to the executive order and HF 146. Our first claimant is the king himself. At a rally, Trump said, quote, he, meaning Walz, signed a law letting the state kidnap children to change their gender so they go home, but I'm not talking about him, I'm talking about her, meaning Kamala, end quote. Now I'll run the clip of him saying that, but I do want to be careful and warn you that if there are any kids around, the T word is going to be said during this clip. So pause here if you need to, and if women's reproductive health is a topic that makes you uncomfortable, you might want to skip forward a minute or so into the episode. I'll go ahead and play the clip now.
Do we have any children here? Please close your ears. He ordered tampons in boys' bathrooms, okay? He signed a law letting the state kidnap children to change their gender so that they go home. But I'm not talking about him, I'm talking about her. This is her ideology. That's why she picked him.
J.D. Vance echoed Trump's claims in an ABC interview with Jonathan Karl, saying, quote, one way of minding your own damn business, John, is to try not to take my children away from me if I have different moral views from you, end quote. Next we have Megyn Kelly's post on her Instagram saying, quote, Tim Walz signed a bill that lets the state take away our kids if you do not agree to sterilize them and chop off their body parts in the name of gender-affirming care. So if your 14-year-old is sad but thinks it's gender confusion and you object to castrating him, the state takes custody. End quote. For our last claim, we've got an article from The Hill by Matt Sharp where he argues that the trans refuge bill, HF 146, threatens parental custody. The article says, custody challenges should be heard in the state where the parent's child and relevant evidence are located, and they should be decided based on the laws of the home state. It also says, if anyone, a parent, close relative, or even an unrelated adult seeks custody of a child for the purpose of obtaining gender-affirming healthcare, then that person can take the child to Minnesota, where state courts now have exclusive jurisdiction to hear the case. Those courts will decide custody of the child and ultimately whether the child will be put on harmful puberty blockers and cross-sex hormones based on Minnesota law. Finally, Matt Sharp states, it isn't just woke relatives that receive a get-out-of-jail-free card when they abscond to Minnesota with a child who's been ripped from the arms of her parents, who are her best advocates and defenders. This law will allow Planned Parenthood and other gender clinics to push life-altering transition drugs on children with no meaningful oversight or accountability. Finally, it's time to dig into the executive order and see exactly what it says for ourselves. Try to keep in mind the claims being made about the order while reviewing it so that you're looking out for anything that could be suspicious or indicative of the truth of these claims. I, Tim Walz, Governor of the State of Minnesota, by the authority vested in me by the Constitution and applicable statutes, issue the following executive order. The Minnesota Constitution explains that government is instituted for the security, benefit, and protection of the people. All Minnesotans have the right to be free from discrimination, including discrimination on the basis of gender identity and gender expression. Minnesota strives to be a welcoming and supportive place for LGBTQIA+ community members. We uphold the essential values of one Minnesota when all people, including members of the LGBTQIA+ community, are safe, celebrated, and able to live lives full of dignity and joy. Throughout the course of their lives, transgender, gender-diverse, non-binary, and genderqueer individuals may decide to seek gender-affirming healthcare services. This deeply personal decision is made with the guidance of medical professionals. Like all medical treatment, gender-affirming care must align with standards that ensure safe, appropriate, and well-established practices. The availability of gender-affirming healthcare services is essential to the health and wellness of LGBTQIA+ community members and is supported by numerous major professional associations, including the American Medical Association, the Minnesota Medical Association, the American Academy of Child and Adolescent Psychiatry, the American Academy of Pediatricians, the Endocrine Society, the Society for Adolescent Health and Medicine, the American Psychological Association, the American Psychiatric Association, the World Professional Association for Transgender Health, and the Centers for Disease Control and Prevention. While gender-affirming healthcare services remain legal and protected in Minnesota, other states have curtailed access to or even criminalized this care. In those states, medical professionals providing gender-affirming healthcare services may be subject to civil liability, criminal liability, or professional sanctions. Some states have enacted even harsher restrictions, going as far as to mandate investigations into parents seeking to help their children obtain gender-affirming healthcare services. These actions pose a grave threat to the health of LGBTQIA+ individuals by preventing them from affirming their gender identities through safe and scientifically proven treatments. In Minnesota, we value LGBTQIA+ community members and we safeguard their rights. LGBTQIA+ people are entitled to respect, compassion, and a free existence as authentic versions of themselves. We are committed to protecting access to gender-affirming healthcare services. No one who is lawfully providing, assisting, seeking, or obtaining such services should be subject to legal liability or professional sanctions. Nothing in this executive order should be construed to change Minnesota law or to require coverage of services that are not considered medically necessary. Instead, this executive order ensures that people in Minnesota are afforded the protections and rights provided under Minnesota law. Today, Minnesota joins other states and a growing number of municipalities across the country that have acted in solidarity with the LGBTQIA+ community. We stand with this community by maintaining a refuge for those who seek and provide gender-affirming healthcare services. For these reasons, I order as follows. And now we begin a definition section. Definitions. For the purposes of this executive order, the terms below are defined as follows. Gender-affirming healthcare services means all medical, surgical, counseling, or referral services, including telehealth services, that an individual may receive to support and affirm that individual's gender identity or gender expression, and that are legal under the laws of the state of Minnesota. State agencies means the department and agencies listed in Minnesota Statutes 2022, Section 1506, Subdivision 1, in addition to the Office of Higher Education and the Department of Military Affairs. 2. State coordination to protect gender-affirming healthcare services. All state agencies must, to the fullest extent of their lawful authority, pursue opportunities and coordinate with each other to protect people or entities providing, assisting, seeking, or obtaining gender-affirming healthcare services in Minnesota. 3. Joint Administrative Bulletin. By November 1st, 2023, the Minnesota Department of Health, MDH, and Minnesota Department of Commerce, the Minnesota Department of Human Services, and the Minnesota Department of Human Rights will issue a joint administrative bulletin based on their direct statutory authority to health plan companies regarding the availability of health insurance coverage and the provision of health insurance benefits for medically necessary gender-affirming healthcare services. 4. Agency actions to protect gender-affirming healthcare services. MDH will use its powers, authorities, and duties to the fullest extent possible to take the following actions. By December 31st, 2023, prepare and present a report to the Governor, Lieutenant Governor, and Legislature summarizing the literature on the scientific evidence about the safety and effectiveness of gender-affirming care and its public health effects, and approaches that other jurisdictions have taken to support gender-affirming healthcare services. Pursuant to its authority, including but not limited to Minnesota Statutes 2022, Section 62D01, Subdivision 2B, request attestations from health maintenance organizations, county-based purchasing organizations, and any other health carrier or health plan under its jurisdiction that they have processes in place to ensure that their contracted health providers are aware they may build a plan for medically necessary gender-affirming healthcare services. Investigate and take administrative action on any complaints of unfair or deceptive acts or practices by a health maintenance organization related to the denial of medically necessary gender-affirming healthcare services in accordance with Minnesota Statutes 2022, Section 62D12, Subdivision 1, and 72A19. To the extent permissible under existing law, accept health maintenance organizations' determinations that medically necessary gender-affirming healthcare services are comprehensive health maintenance services and therefore not a permissible exclusion under Minnesota Rules 2022, Part 4685.0700, Subpart 4. To the extent permissible under existing law and pursuant to its authority under Minnesota Statutes 2022, Section 62D04, refuse to approve any health maintenance organization, contract, or evidence of coverage that discriminates against individuals on the basis of sex, sexual orientation, gender identity, or gender expression, consistent with the Joint Administrative Bulletin referenced in paragraph 3 of this executive order. Commerce will use its powers, authorities, and duties to the fullest extent possible to take the following actions. Pursuant to its authority under Minnesota Statutes 2022, Section 60A.03, Subdivision 2, and Section 62A.02, and by November 1st, 2023, request attestation from health plan companies that they have processes in place to affirm that their contracted health providers are aware they may bill for medically necessary gender-affirming healthcare services. Investigate and take administrative action on any complaints of unfair or deceptive acts or practices in the business of insurance related to the denial of medically necessary gender-affirming healthcare services in accordance with Minnesota Statutes 2022, Section 72A.19. To the extent permissible under existing law and pursuant to its authority under Minnesota Statutes 2022, Sections 62A.02 and 72A.21, refuse to approve any health plan that discriminates against individuals on the basis of sex, sexual orientation, gender identity, or gender expression in accordance with Minnesota Statutes 2022, Sections 62A.02 and 72A.21. and consistent with the Joint Administrative Bulletin referenced in paragraph 3 of this executive order. DHS will evaluate the Minnesota Healthcare Program's Provider Manual for consistency with current standards and recommendations for medically necessary gender-affirming healthcare services. By September 1st, 2023, DHS will update the Provider Manual if necessary to ensure that up-to-date medically necessary gender-affirming treatments are covered health services that are eligible for reimbursement by MHCP under Minnesota Rules 2022, Part 9505.0210. MDHR will use its powers, authorities, and duties to the fullest extent possible to file commissioner's charges of discrimination, investigate charges of discrimination, file complaints or civil actions, and/or seek injunctive relief when the commissioner has reason to believe that a healthcare provider, insurance company, or educational institution has engaged in unfair discriminatory practices in violation of Minnesota Statutes 2022, Chapter 363A. No assistance from state agencies to states seeking to penalize gender-affirming healthcare services. Except as required by court order or by Minnesota or federal law, no state agency may provide any information or expend or use time, money, facilities, property, equipment, personnel, or other resources in furtherance of any investigation or proceeding that seeks to impose civil or criminal liability or professional sanctions upon a person or entity for the provision of, securing of, receipt of, or any inquiry concerning gender-affirming healthcare services, or any assistance given to any person or entity that relates to the provision of, securing of, receipt of, or any inquiry concerning gender-affirming healthcare services. To the maximum extent permitted under the United States and Minnesota Constitutions, federal law, and Minnesota law, no state agency will enforce or recognize a judgment from another state terminating parental rights or restricting a parent or legal guardian from contacting their child solely because the parent or guardian sought to obtain or did obtain gender-affirming healthcare services for their child. To the maximum extent permitted under the United States and Minnesota Constitutions, federal law, and Minnesota law, no state agency will comply with a subpoena issued in another state seeking information about a person or a person's child who travels to this state for gender-affirming healthcare services related to potential child protection matters or criminal charges against a parent, guardian, or provider for seeking, obtaining, or providing gender-affirming healthcare services. Protection against extradition. To the maximum extent permitted under the United States and Minnesota Constitutions and Minnesota Statutes 2022, Chapter 629, and in consultation with the Minnesota Attorney General pursuant to Minnesota Statutes 2022, Section 69.04, I will exercise my discretion to decline requests for the arrest or surrender of any person charged with a criminal violation of a law of another state where the violation alleged involves the provision of, assistance with, securing of, or receipt of gender-affirming healthcare services unless the acts forming the basis of the prosecution of the crime charged would also constitute a criminal offense under Minnesota law. This executive order is effective 15 days after publication in the State Register and filing with the Secretary of State. It will remain in effect until rescinded by proper authority or until it expires in accordance with Minnesota Statutes 2022, Section 4.035, Subdivision 3. A determination that any provision of this executive order is invalid will not affect the enforceability of any other provision of this executive order. Rather, the invalid provision will be modified to the extent necessary so that it is enforceable. Signed on March 8, 2023 by Governor Tim Walz. Now, let's also take a look at Minnesota's Trans Refuge Bill, HF 146, because maybe that's where the state is granting these kidnapping powers. It's important to note that the people making these claims should make it clear where to look to confirm their claims. We shouldn't have to find their source for them. The bill is a series of amendments to current legislation that aim to reach similar goals to Walz's executive order that we just read, and it was passed by the Minnesota House and Senate and then signed by Governor Walz. For those just listening, we're going to go through and find the bolded sections which represent the amendments, but I'll try to explain their context within the document, and the entire bill will be linked in the description if you want to read the whole thing. I'm just trying to help give people exposure to these primary sources, but I also don't want to bore you all to death. The bill starts, a bill for an act relating to children, preventing the use of subpoenas to gather information for out-of-state laws interfering in the use of gender-affirming healthcare, amending child custody and child welfare provisions related to out-of-state laws interfering in the use of gender-affirming healthcare, amending provisions related to warrants, arrests, and extraditions related to out-of-state laws on gender-affirming healthcare, amending Minnesota statutes 2022 sections 518D 202, 518D 204, 518D 207, 69.02, 69.05, 69.06, 69.13, and 69.14, proposing coding for new law in Minnesota statutes, chapters 260 and 543. Be it enacted by the legislature of the state of Minnesota. Section 1, 260.925, Application of Laws, Gender-Affirming Healthcare. A law of another state that authorizes a state agency to remove a child from the child's parent or guardian because the parent or guardian allowed the child to receive gender-affirming healthcare as defined in Section 543.23, paragraph B, which is going to be coming later in the bill, which I'll read, is against the public policy of this state and must not be forced or applied in a case pending in a court in this state. A court order for the removal of a child issued in another state because the child's parent or guardian assisted the child in receiving gender-affirming healthcare in this state must not be enforced in this state. Section 2 amends the Initial Child Custody Jurisdiction Law 518D.201 to read, the presence of a child in this state for the purpose of obtaining gender-affirming healthcare, as defined in Section 543.23, paragraph B, is sufficient to meet the requirements of paragraph A, clause 2, item I, which reads, the child and the child's parents, or the child and at least one parent, or a person acting as a parent, have a significant connection with this state other than mere physical presence. And this is referring to point 2, which says a court of another state does not have jurisdiction under Clause 1, or a court of the home state of the child has declined to exercise jurisdiction on the ground that this state is the more appropriate forum under Section 518D.207 or 518D.208. Now, when we relate the amendment, Part D, to Section 2, Part I, which it is referring to, it is clearly simply saying that being in the state for the purpose of obtaining gender-affirming healthcare counts as having a significant connection with this state other than mere physical presence. The amendment to 518D.204, Temporary Emergency Jurisdiction, reads, the child has been unable to obtain gender-affirming healthcare as defined in Section 543.23, paragraph B, and the Temporary Emergency Jurisdiction Law says that a court of this state has temporary emergency jurisdiction if the child is present in this state, and basically, there are two reasons that are already given. The child has been abandoned, or it is necessary in an emergency to protect the child because of the child, or a sibling or a parent of the child is subjected to or threatened with mistreatment or abuse. And so the amendment is just adding on a child being unable to obtain gender-affirming health care to the emergency jurisdiction clause as a valid reason to grant emergency jurisdiction to the state of Minnesota. When I first read through this amendment, I was trying my best to read it through a suspicious eye and trying to find anything that could even hint at allowing the state to kidnap children. And halfway through reading it, I thought this was the smoking gun. I thought all the people making these claims were actually right, and I was blown away. But at first, I thought jurisdiction meant the state was taking custody, as in direct control over children. But after rereading it multiple times, I realized that jurisdiction only gives the court the right to hear a case. This experience made me wonder if other people reading this bill were having similar misinterpretations, because custody and jurisdiction have nothing to do with one another, but if you're looking for the part that lets the state kidnap children, you might read this and think it really is the smoking gun you're looking for. In reality, however, kidnapping a child and hearing a custody case for a child in your state's court system are two completely different things. Section 4 amends Minnesota Statutes 518D.207, Inconvenient Forum. The statute itself says, "A court of the state which has jurisdiction under this chapter to make a child custody determination may decline to exercise its jurisdiction at any time if it determines that it is an inconvenient forum under the circumstances and that a court of another state is a more appropriate forum. The issue of inconvenient forum may be raised upon motion of a party, the court's own motion, or request of another court." The amendment to this statute reads, "In a case where the provision of gender-affirming health care for a child is at issue, a court of the state shall not determine that this state is an inconvenient forum if the law or policy of the other state that may take jurisdiction limits the ability of a parent to obtain gender-affirming health care as defined in section 543.23, paragraph B, for the parent's child." Section 5 actually creates a new statute rather than amending a current one. It is labeled 543.23, unenforceable subpoenas, and Part B of it is where they define gender-affirming health care. And I'm not sure why they didn't put it further up in the document, since they're referring to gender-affirming healthcare multiple times in the document. That would make more sense to me. But it reads, Part A, "No subpoena shall be issued and no foreign subpoena shall be recognized in this state or in a criminal or civil matter if the subpoena is related to a violation of another state's laws when the other state's laws are designed to interfere with an individual's right to receive gender-affirming healthcare. Failure to comply with a subpoena taking information related to a person or entity allowing or assisting a child or an adult to receive gender-affirming healthcare when the information is being requested to enforce another state's laws that allow a civil or criminal action to be brought against a person for allowing or providing gender-affirming healthcare must not be the basis for contempt under section 588.01. Part B. Gender-affirming healthcare means medically necessary care or mental health care that respects the gender identity of the patient as experienced and defined by the patient, and that may include, but is not limited to, 1. Interventions to suppress the development of endogenous secondary sex characteristics. 2. Interventions to align the patient's appearance or physical body with the patient's gender identity. 3. Interventions to alleviate the patient's symptom of clinically significant distress resulting from gender dysphoria as defined in the current version of the Diagnostic and Statistics Manual of Mental Disorders. And 4. Developmentally appropriate exploration and integration of the patient's gender identity, reduction of the patient's distress, adaptive coping, and strategies to increase family acceptance of the patient's gender identity." Now, I could see someone hearing Part 4, and when it says, "and strategies to increase family acceptance of the patient's gender identity," thinking that the state is trying to impose a belief system upon the patient's family, and the patient being, in this case, a minor. That doesn't really make sense. I think that is a very valid point of debate, but that has nothing to do with kidnapping, because this whole clause, as you read in Section A, is referring to what can be considered basis for contempt. And so what it's just saying is that the government of Minnesota does not have to help other states with providing information or complying with subpoenas if the other state is trying to do any of these 4 points. I just want to note things like that because I don't think that this is a settled topic, and I think the election also really showed the Democratic Party that the United States does not love their messaging on this topic, although I know there were many other things involved in the outcome of the election. But I don't think that it should be considered simple or obvious. But I also think that people on both sides of the political spectrum need to have compassion for people who are having gender identity issues and trying to hear what their concerns are and what their lives are like, while also striving to make sense of this issue between parties and within parties and as a society together, rather than simply virtue signaling on the left and witch hunting on the right. Section 6 amends 629.02 Duties of Governor in Extradition Matters. It reads, subject to the provisions of Section 629.01 to 629.29, the provisions of the Constitution of the United States controlling and any and all acts of Congress enacted in pursuance thereof, it is the duty of the governor of this state to have arrested and delivered up to the executive authority of any other state of the United States any person charged in that state with treason, felony, or other crime who has fled from justice, and if found in this state. Now, the text added onto the end here is the amendment, which reads, nothing in this section shall limit any person's right to move freely between states or to enjoy the privileges and immunities of this state, and no person shall be arrested or delivered up to the executive authority of any other state of the United States for acts committed in this state or services received in this state involving gender-affirming healthcare as defined in Section 543.23, paragraph B. Section 7 amends Statute 629.05, extradition by agreement, and the amendment is added on to the end, so I'll read the whole statute. When it is desired to have returned to this state a person charged in this state with a crime, and such person is imprisoned or is held under criminal proceedings, then pending against the person in another state, the governor of this state may agree with the executive authority of such other state for the extradition of such person before the conclusion of such proceedings, or the person's term of sentence in such other state, upon condition that such person be returned to such other state at the expense of this state as soon as the prosecution in the state is terminated. The governor of this state may also surrender on demand of the executive authority of any other state any person in this state who was charged in the manner provided in Section 629.23 with having violated the laws of the state whose executive authority is making the demand, even though such person left the demanding state involuntarily. Now the amendment here adds, except that no person shall be surrendered for acts committed in this state or services received in this state involving gender-affirming healthcare as defined in Section 543.23, paragraph B. 8 amends Statute 629.06, extradition of persons committing crime. An amendment is added in the very beginning, Part A, where it says, except as provided in paragraph B, and then we're going back to the original statute here, the governor of this state may also surrender on demand of the executive authority of any other state any person in this state charged in such other state in the manner provided in Section 629.03 with committing an act in this state or in a third state intentionally resulting in a crime in the state whose executive authority is making the demand, and the provisions of Section 629.01 to 629.29, not otherwise inconsistent, shall apply to such cases even though the accused was not in that state at the time of the commission of the crime and has not fled therefrom. And then a second amendment is added to the bottom of this statute, which reads, nothing in this section shall limit any person's right to move freely between states or to enjoy the privileges and immunities of this state, and no person shall be surrendered to the executive authority of any other state for acts involving gender-affirming healthcare as defined in Section 543.23, paragraph B. Section 9, Statute 629.13, who may be apprehended. This is amended in the middle, so I will start but then tell you when the amendment is introduced. It reads, when any person within this state is charged on the oath of any credible person before any judge of the state with the commission of any crime in any other state, and then an amendment is inserted right here, which reads, other than a crime arising from acts committed in the state or services received in the state involving gender-affirming healthcare. And then that amendment is over, but I'll finish reading this statute. And except in cases arising under Section 629.06, with having fled from justice, with having been convicted of a crime in that state and having escaped from confinement, or having broken the terms of bail, probation, or parole, or when complaint has been made before any judge in this state setting forth on the affidavit of any credible person in another state that a crime has been committed in the other state, and that the accused has been charged in that state with the commission of the crime, and except in cases arising under Section 629.06, has fled from justice, or with having been convicted of a crime in that state and having escaped from confinement, or having broken the terms of bail, probation, or parole, and is believed to be in this state, the judge shall issue a warrant directed to any peace officer commanding the officer to apprehend the person named in it, wherever the accused may be found in this state, and to bring the accused before the same or any other judge or court who or which may be available in or convenient of access to the place where the arrest may be made to answer the charge or complaint and affidavit. A certified copy of the sworn charge or complaint and affidavit upon which the warrant is issued shall be attached to the warrant. Section 10 is the last amendment, and it amends Statute 629.14, arrest without a warrant. The statute reads, "The arrest of a person may be lawfully made by any peace officer or private person without a warrant upon reasonable information that the accused stands charged in the courts of a state with a crime punishable by death or imprisonment for a term exceeding 1 year." And an amendment is inserted right here, which reads, "Except that no person shall be arrested if the accused stands charged in the courts of any other state for acts committed in this state or services received in this state involving gender-affirming healthcare, as defined in Section 543.23, paragraph B." And then that's the end of the amendment, and the statute starts again. "When arrested, the accused must be taken before a judge with all practicable speed, and complaint must be made against the accuser under oath setting forth the ground for the arrest in this Section 629.13. Therefore, the answer shall be heard as if the accused had been arrested on a warrant." And that is the end of HF 146. Now that we've read through the executive order as well as HF 146, we can finally start analyzing these claims. But first, just ask yourself, did you hear anything that allowed the state to take custody of your child within either of those documents? We'll start with the claims of the Hill article. The article says, quote, "Custody challenges should be heard in the state where the parent's child and relevant evidence are located, and they should be decided based on the laws of the home state," unquote. This is really just an assertion, and it doesn't seem like it's obviously how states should handle their residents doing things in locations where they are, in fact, legal. Also, when he says where relevant evidence is located, it seems plausible that much of the relevant evidence would be in the state where said actions took place, and that is counter to the argument Matt Sharp is making. He's claiming to argue in favor of parental rights, but it seems more like the only rights he's favoring are the state's rights of the state he agrees with. It's important to note that none of these criticisms hinge at all on whether or not it is in fact advisable to seek that care, but rather only on who should be allowed to decide. Next, the article says, "If anyone, a parent, close relative, or even an unrelated adult, seeks custody of a child for the purpose of obtaining gender-affirming health care, then that person can take the child to Minnesota, where courts now have exclusive jurisdiction to hear the case. Those courts will decide custody of the child and, ultimately, whether the child will be put on harmful puberty blockers and cross-sex hormones based on Minnesota law." Mr. Sharp is right about one thing here, which is that Minnesota state courts would decide custody of the child. We'll come back to this when the article contradicts itself later on, but let's zoom in on where he says, "for the purpose of obtaining gender-affirming healthcare." And note that this isn't even in the executive order, and Mr. Sharp doesn't provide a citation or link for the quote to begin with, as you can see here. So I thought that was confusing. Next, and lastly, he says, quote, "And it isn't just woke relatives that receive a get-out-of-free-jail card when they have gone to Minnesota with a child who has been ripped from the arms of her parents, who are her best advocates and defenders. This law will allow Planned Parenthood and other gender clinics to push life-altering transition drugs on children with no meaningful oversight or accountability. And under the Minnesota law, Planned Parenthood could easily encourage and pay expenses for a teenager to travel to the state for harmful transition drugs, and it would do so with the assurance that the state shields it should the parents try to intervene to save their child from the lifelong consequences of these drugs. End quote. Mr. Sharp seems to think that simultaneously those courts will decide custody of the child, and also that woke relatives will get a get out of jail free card, and state law shields Planned Parenthood from any legal consequences for anything they could ever do, even though Walz's executive order says, quote, I will exercise my discretion to decline requests for the arrest or surrender of any person charged with a criminal violation of a law of another state where the violation alleged involves the provision of, assistance with, securing of, or receipt of gender-affirming healthcare services. And here's the important part. Unless the acts forming the basis of the prosecution of the crime would also constitute a criminal offense under Minnesota law. This makes clear that seeking gender-affirming care does not automatically grant a legal shield for other crimes done in the process of seeking it, for example, abducting a child and taking them to Minnesota. Also, the claim that Planned Parenthood can push life-altering transition drugs on children with no meaningful oversight or accountability neglects to acknowledge that on the Planned Parenthood website, as you can see here, children cannot go to Planned Parenthood and then start hormones without any consent from their parents. And it even says you might be required to get a formal diagnosis of gender dysphoria to get gender-affirming care or to get your care covered by your health insurance plan. The doctors who make these diagnoses factor in your age and how long you have known your gender. That indicates that at least there is some level of accountability and risk awareness in providing this care, which I think should make most people feel at least somewhat better. Now we'll return to Trump's claim that, quote, Walz signed a law letting the state kidnap children to change their gender so that they go home, but I'm not talking about him, I'm talking about her, meaning Kamala.
I really don't know what he said at the end of that sentence. I don't think he knows what he said either.
Next up we have Megyn Kelly, who claimed, quote, Tim Walz signed a bill that lets the state take away our kids if you do not agree to sterilize them and chop off their body parts in the name of gender-affirming care. So if your 14-year-old is sad but thinks it's gender confusion and you object to castrating him, the state takes custody. End quote. So as we covered, there's nowhere in either of these bills that says that the state has legal authority to grant itself custody of someone's child for neglecting to get the child gender-affirming care. It only grants the state the jurisdiction to hear a case at all. And let's not forget, gender-affirming care doesn't even have to mean medical interventions as defined in Walz's executive order. The definition used includes all medical, surgical, counseling, or referral services, including telehealth services, and a study published by Harvard looked at national rates of gender-affirming surgeries in minors and found that the rate of undergoing a gender-affirming surgery with what they called a transgender or gender-diverse diagnosis was 2.1 per 100,000 minors aged 15 to 17 years and 0.1 per 100,000 minors aged 13 to 14 years, and 0 procedures among minors aged 12 years or younger. And it's important to mention that cisgender males made up 146 breast reductions out of the 141 found by the study. That means just teenage dudes who are uncomfortable about the size of their chests. The study used the most recently available data from a 2019 nationally representative pool of medical insurance claims to identify individuals who received gender-affirming surgery. Now let's look at JD's claim, which will help us segue into the different interests involved in all of this and who should be given legal priority when disputes arise between citizens, their home states, and states they travel to. Tell me, if a bill allows parents to go to a state and exert their freedoms within that state, and their home state wants to punish them for exercising those freedoms, who is infringing upon the parents' rights? In Texas, for example, the Attorney General Ken Paxton wrote in opinion number KP 0401 that, quote, regarding parental consent, Texas law generally recognizes a parent's right to consent to a child's medical care, To consent to certain medically necessary procedures does not extend to elective procedures and treatments that infringe upon a minor child's constitutional right to procreate. And each of the sex change procedures, treatments enumerated above, when performed on children, can legally constitute child abuse under several provisions of Chapter 261 of the Texas Family Code. When considering questions of child abuse, a court would likely consider the fundamental right of procreation, issues of physical and emotional harm associated with these procedures and treatments, consent laws in Texas and throughout the country, and existing child abuse standards. End quote. Now, I wonder what JD would say if Texas courts ruled that a parent has their child custody revoked on their seeking gender-affirming health care for their child. Would he defend a parent's right in this scenario since he thinks the state shouldn't take your kids away if you have different moral views? What do you, the viewer, think parents should have a right to do in regard to their children and what they think is best, especially in conversation with doctors? I think most people would agree that there should be a limit to everything, but that we also don't want to unfairly restrict the freedoms of individuals when they are trying to live the life that they think is best for themselves. I want to end with a challenge for people who still think these claims are accurate, and then a few questions. I want any evidence of Minnesota taking a child away from their parents with their only justification being that the parents would not provide the child with the care they wanted. I also want evidence of a child crossing state lines into Minnesota and getting gender-affirming care from Planned Parenthood. I want evidence of any existing legal precedent in Minnesota enforcing custody for gender-affirming care against the will of both parents without factors other than neglect or abuse. I'd like to end on a reflection. Why aren't these people citing the text of the bill, and why don't they have examples of people's kids being kidnapped by the state of Minnesota? The bill was in 2023. They didn't cite the text or legal cases of the bill being used to kidnap people's children. If this was a real thing that happened, there would be court documents, and it would be perfect for conservative news coverage. So where is it? People who don't substantiate their claims like this don't want you to think. They don't even want evidence to be something that you value because they only want you to listen to them because they're trying to use you. I'd like to thank you all for listening, and I'll see you next time on Ideas in Flux.